Yes.
My lord, maybe pardon to mention item 34.
34.
34. My lord, it has come under the noting that it is to be withdrawn. My lord,
To withdraw that?
yes, your lordship. My lord, has not pressed your lordship. Has not pressed your lordship.
Not this. Great.
My lord, item 37.
I would say withdrawn in terms of memo.
As your lordship asks.
My lord, item 37, I filed an IA for withdrawal. Yes. And in case the cause of action survives, I may be given a liberty too.
Pardon to mention, my lord.
Give that application. One memo would have been sufficient. Huh?
I am also giving a memo also, my lord.
Your file memo also.
I'll just give it now if it's required.
This application is not necessary.
Oh, my lord, I'll give a memo.
Serious. You write only this much. The petitioner has moved an application within prayer reads at the time. Question is this board of
Pardon to mention.
in terms of proceed prayer.
Pardon to mention, my lord. Item 236 in the weekly list. Permitted to withdraw. Liberty to file better application, my lord.
Why not happy with the court? So
Yes,
many
well, no, some-
are being withdrawn. This is not a happy thing.
Some annexure has been not given, that's it.
Nobody should go with the heartburn from the court because court is a temple. That way. Yes, in terms of
Item 45.
Okay, Your Lordship.
45.
Yes, I have appealed for the state election board here. I paid this gives time to file a count. I have not filed this.
If any other person is there, opponent is there.
Nobody there, but there is no interim application there.
No interim application. Post in the first week of November, actually. Question.
Lordship, item number 35. 35, filing a memo for withdrawal. Lordship, it has become infructuous.
Structures. Is in terms of has become infructuous.
Item 48. 48 in the list.
48.
Taken up. That the student is, I have filed that, prepared that affidavit. Dates, my lord, have put me when you applied, when you have received the census kit. And I have
Revaluation, etc.
Yes, that one. Can you take?
You mentioned it at around 11:40.
Item 47.
Today, any court is not full today. Everybody is in a festive mood,
That is a.
including the judge.
Yes.
Item 47. Counter has not yet come. I pray let it come after vacation.
After vacation, first week, second week of November.
And entry order to continue.
Entry order is there. Then third week of November, entry order to continue. Yes.
Yes. Item 1.
Please, Your Lordship. This is a matter relating to the allotment of lead in respect of a Indian Navy official who was that.
Where are your friends? Your friends perhaps are held up
No
in
one.
traffic today. Wait. Pass over. Send words for the AGA.
Item 2.
Item number 2, Your Lordship. Respect to appear on behalf of the substituted legal heirs, Your Lordship.
You want to appear for legal aid?
Lordship, substituted legal heir. The original petition is in the meantime has already been died, Your Lordship. And the substituted legal heirs, serial number 1, Shakuntala Agarwal is also died, Your Lordship.
Heir also died.
Lordship, she has also died.
Litigant died, litigant's heir died. And other heirs are to come on record now.
Others are already in record, Your Lordship.
They are on record.
Records, Your Lordship.
So the cause of action survives.
Survives, Your Lordship. Already on the record, Your Lordship. I will give you from serial number 3 to serial number 8, Your Lordship.
3. So it appears serial number 3 to 8. And submits that the cause of action survives despite the death of one of the LRs. Who is that? LR number?
LR number 1, Shakuntala Agarwal.
Without.
Despite
the death of LR Srimati Shakuntala.
Yes.
Sorry.
Already in the consolidated first title has already been filed, Your Lordship. They have already been substituted. Consolidated first title has been filed. And then serial number
Serial number 2.
Sorry, I'm sorry, sir. Serial number 1, Your Lordship. I'm sorry, Your Lordship. Shakuntala, serial number 1.
First one. He also submits that the substituted cost title is the cost title is also substituted. No need to bring other LRs. Shakuntala's LRs need not be brought on record.
That all the Shakuntala, Your Lordship, original petitioner is the Vasudev Agrawal. Vasudev Agrawal's wife is the Shakuntala Agrawal and he has 6 sons and daughters. Your Lordship,
All sons and daughters are here now.
Lordship.
He also tells that the estate of the deceased is fully represented by the survivors who are loaded to cost title. And there is no need to bring LRs of deceased Shakuntala since the existing LRs happen to be her LRs as well. Okay. 2004 matter. Argue.
What matter, Your Lordship?
Just 21 years have elapsed.
Your Lordship has been having. Last, Your Lordship, and the morning I got instruction, Your Lordship.
The morning you got instruction.
And Your Lordship,
What is there? Let us see. If there is something, I will try.
even if I do not got the entire file, Your Lordship.
So don't have it certified.
Today morning, on telephoning, it's my due prayer, Your Lordship, kindly come.
Alright. Though this matter is more than 2 decades old, on the request of learned counsel appearing for the LRs of the deceased, who pleads some difficulty, call this matter Ollie, soon after vacation. Good notice.
2009, there is an interim order, Your Lordship.
2009,
Lordship.
whether it continued.
Fortunately, that has not been.
But then, how can I continue at this later stage? I do not know what all had changed. The world had changed after 2009. They have seen. I do not know what will be the consequences.
There is constable, Lordship, I think.
Nothing.
Obliged. I mean,
Lordship direct them to produce the list deed. Executed earlier.
Petitioner.
I have to wait. Your Lordship, I have to verify the records. And
No, we are telling you. You produce the list deed.
List deed.
Yes. Petitioner to produce list deed on the next date of hearing. Non-production may be viewed, may result into drawing an adverse inference against them. Okay. On 15, 16. 16. Registry to supply the copy, the pleadings in a pen drive form. It's applied. Okay.
Status completed. Item 1.
Yes, it is. He said he does not have papers, no? If he wants, give entire papers. Okay.
password method.
Password method. Yes, Mr. G.
Item 1.
Yes.
The Lordship directed me to obtain concrete instruction in the meantime.
Correct.
Because of the paucity of time, I cannot get that instruction. Lordship may kindly call this matter a day after vacation so that on 9th, your Lordship may kindly call this matter. I will get that, my Lord. It's a matter relating to
Navy man.
The Navy man that is approaching 80 years is loitering, my Lord.
Mr. G.
I know, my Lord. I am conscious, my Lord.
I feel very bad when our soldiers.
I
you
too,
kindly understand.
my Lord. I too.
We are sitting here so calm because soldiers are guarding us.
Yes.
And if you treat the soldiers as if they are criminals,
No. It is not that. My
lay down
Lord,
his life.
my Lord, it is only some paucity of time. I cannot get that.
Should assure that something positive will happen.
Yes, I hope so, my Lord.
As a long last, call this matter on 9/10.
But should I call this matter any day, any 9 or 10, any day, my Lord, I will bring that.
9/10/2025.
Oh, my Lord, yes.
All right? Something should happen. Otherwise, I will make something to happen.
Yes, my Lord.
Yes. What is this kind of soldier? See that soldier sitting there. He fought for the country and he is sitting on the last bench, having retired from service.
Yes.
Approaching 80 years.
80 years. And that site is kept still vacant. Site is still available. That's what the other side said.
On that date, Mr. Mahapatra said that.
Don't treat soldiers that.
No.
God will not forgive us. Really, I tell you, God will not forgive. Some rich people, industrial people, business people, they will be able to tolerate. Small people, what they should do, where they should go, how many years they have to wait, and what he should do with that site now at this age. He can walk there, that's all.
They cannot walk also.
They cannot walk also. Therefore, you tell the government. Otherwise, the reputation of the government would be tarnished, I tell you. That should not happen. That should not happen. But of course, you are entitled to argue and merits is another thing. Yes.
Please.
Item 3.
Yes.
In this case, Madam, kindly give me the order that not in your case. 23/9/2023 order may kindly be given to me. So that
Do you want copy of the order?
No, not this. Item 1.
Item 1.
My lord.
You want order?
Order, copy of the order. So that I will mail them. Mail the Chief Secretary today. To take care of this issue.
Any order we have to. One sentence you have to read that order. That's fine. So, first time. Okay. This court expresses anguish the way a retired defense personnel is being treated at the hands of the government and its functionaries. First. Of course, all contentions of parties are kept open for being advanced on the next date of hearing. Okay. First, the copy of order to be
My lord.
carbon copy, the pencil copy to be furnished to the learned AGA. The G. Yes. You tell the man to take that copy to his office. Okay? Yes.
Item 3.
Item 3, suppliers similar copy notice has been issued.
Notice was issued.
Yeah. 3. Issue notice. Similar. Next.
Item 4.
Yes, sir.
The petition to engage in physical education instructor in the identical issue, Lordship will pass the order, that is Annex of 4, directing the opposite party to consider the representation. The same order will pass. Annex of 4, Lordship.
Okay.
21.
In the light of Jago, that representation will be
There.
Only Lordship is running page 22, the Annex of 5 has to be Annex of 3 in the present case.
Annex 6.
Annex of 5 has to be Annex of 3.
That's all.
Lordship.
The rest of the things will remain as it is.
Lordship.
This judgment is at Annexer
Annex of 4.
4. Annexer 4. It refers to document as Annexer 5. Is it not? No, it does not. Simply it makes consider that they will have reproduction. I'm so confused. Instead of Annexer 5, it should be
Annex of 3.
Annexer 6.
Annex of 3, Lordship. Not
Annexer 3. 3. Obviously.
Same order.
Same.
You have to show him. You want the entire petition.
My lord, I am suggesting him to speak the right thing so that there could not be any mistake.
Correct. Correct.
Item 5.
Lord, here is the petitioner is now working as a lecturer in zoology, my lord. My prayer, my lord, to transfer him from district of Devagod to Khordha district, my lord. Here, my lord, now he is suffering from cardiac disease and is the only son. Now mother is bedridden, my lord. Now the Devagod district is more than 300 kilometers from the Khordha. That's why I am filing a representation before the director, that is Annexer 3, praying for deploy in Khordha district so that he will able to take care of his mother as well as his health condition.
You are a lecturer.
Yes, lecturer in zoology. Page 10 is my appointment letter.
In which college, university?
The college, the added college, Plasma Science Degree College, they've got page 10, Annex 1.
In degree colleges, who is the authority to transfer you?
Director,
Director
higher education.
Consider that representative. There is a patient.
Yes.
Yes. And aged mother. Who is looking after parents nowadays? All parents have become destitutes. Nobody to look after. And you have seen that 2007 Act.
My lord. Yes.
Senior Citizens Protection Act.
Yes.
So therefore, in the light of that, you have to consider these things.
He has given representation.
And it remains as it is. Take down. A lecturer in an aided college is grieving against non-consideration of his representation dated 19/7/2025, which is self-explanatory and therefore is reproduced. You reproduce that. Page
25-26.
25-26. Next paragraph. Learned counsel for the petitioner submits that she has undergone some surgery in heart-related ailment, and that he has to look after aged parents.
My lord.
Parents. Both are there.
No, only mother, my lord.
Aged mother, who is in the evening of her life. And she has diseases natural to the old age. First off, he further adds that even under the Senior Citizens Act, Right to Protection, some act is there, 2007 Act. Come on, there is a duty cast on the children to look after aged and ailing parents. First off, despite that, he submits, his representation remains with a stony silence from the side of officials, and therefore indulgence of this court is eminently warranted. First off, kindly be sitting. Learned AGA Mr. G, on request accepting notice for the OPs, very fairly submits that such representations ordinarily are to be considered, keeping in view a host of factors, and that he would instruct OP number 2,
Director Higher Education,
to look into the grievance of the petitioner as has been aired in the subject representation, if all contentions are kept open and a reasonable period is afforded. First off, this is really appreciable. Next paragraph. In the our Smritikaras say, Rakshanti Havire Putra, literally meaning it is the duty of son to look after mother in the old age. First one. The scriptures are not just for chanting like mantras. First one. They should animate the decisions of the welfare state and its functionaries. First, much is not necessary to specify, and less is insufficient to leave the things unsaid. First, next paragraph. In the above circumstances, this petition is disposed of 2 weeks. Within 2 weeks, there is nothing left. It is open to solicit any information from the side of petitioner. We have to show that mother is old, she wants your help. There is no other person.
Yes.
And
You have suffered your
and his element
problem. These things you have to put.
Yes.
Okay?
Item 6.
My lord, here inter-district transfer has been rejected because of that clause 2L.
Similar matter, we have
Notice has been issued.
not issue emergent notice, call along with WP number.
Yes, sir.
That's fine.
Item 7.
Wait. In
That
similar,
clause itself is not applicable.
yes. In a similar matter, Your Lordship issue notice.
We have issued notice.
Yes.
Say one word, what is about the matter?
Matter relating to regulation.
Regularization. Issue notice, call along with WP numbers. Yes.
Item 8.
Item 8, please, Your Lordship. Lordship, this present writ application has been filed challenging the illegal actions of the opposite party number 2 as well as opposite party number 3, Your Lordship.
What is that illegal?
Opposite party number 2, the sub-collector. It started with opposite party number 3, the Tahsildar, who issued a legal certificate despite knowing that there was an ongoing civil dispute.
Civil suit is there.
Yes, civil suit is there. The opposite party number 5.
1 second, making one step. Allow just to contemplate on that. Now, that certificate will be subject to outcome of the suit.
Your Lordship, as per the Odisha miscellaneous certificate rules, the rules 5 is a bar, which states that if there is an ongoing civil suit before any competent authority, court, then the same shall, the particular applicant shall go to the civil court for applying for a succession certificate rather than the Tahsildar issuing a legal heir certificate pursuant to the application filed by the applicant.
Read.
Yeah, if Your Lordship wants, I can
read that.
Section Rule 5 criteria for issuance of miscellaneous certificate. Sub Rule 2 says that legal heir certificate shall be granted for the following reasons. Then it is mentioned that the proviso that provided that in disputed cases, the applicants may be advised to approach the competent civil court for issuance of civil succession certificate, provided further that the succession certificates which are governed under the provision of the Indian Succession Act shall not be granted by the revenue officers. Revenue officers being Tahsildar and all those officers who are entrusted to
you, but succession certificate is different. Legal heirship certificate is different.
Yes, Your Lordship. To satisfy Your Lordship on that point, the opposite party number 5 had filed a civil suit before the civil judge for partition and permanent injunction. He had mentioned that he is one of the co-partner and successor of late Brahmavar Patnaik, and he is entitled for all those property which he had scheduled in that civil suit.
You take emergent
during.
My lord's prayer is very narrow compass, my lords. His prayer for a direction to dispose of the appeal pending before the subject.
The short prayer of the petitioner is scripted in the following text, following way. Next paragraph. Learned counsel for the petitioner submits that right to speedy remedy, being a facet of Article 21 of the Constitution of India in the light of category of decisions of the apex court, his appeal cannot be kept pending eternal, the same having been filed in number 17 of 2025 before the statutory appellate authority. Learned AGA, in all fairness, agrees to instruct the presiding officer of the appellate body to take a call in the matter at the earliest, and in any circumstance within 6 months, if all conditions are kept on. First, with this proposal, petitioner.
My lord, may I submit one thing, Your Lord?
Yes.
My lord, we had filed a stay application.
They have not
for
the petitioner submits that.
They returned
regardless of the time period given for disposing of the appeal, the appellate authority is bound to consider his interim application on a war footing. This is agreeable to this court. In the above circumstances and with the above observation, petition is dismissed.
My lord, may I be protected?
All contention be kept open, no protection.
My lord, The operation of the legal certificate, no, maybe
They have filed appeal, application.
till the final
No,
judgment.
they have to do that. Yes.
Item 9.
Yeah.
The services of the petitioner was terminated and he has succeeded in his appeal way back in 2010, 30/11/2010. Appeal, the order of the appellate authority was challenged before this honorable court, but there was no stay order. Still, I was not allowed to join.
Arrears of salary to be
Yes,
paid.
now, my lord, after the intervention of this honorable court, I am allowed to join by the district education officer. But thereafter, he is not taking any step for my release of my salary. I am going without salary for so many years.
You
That is
look
not
into the grievance.
Welcome.
Welcome. The short grievance of the petitioner is reflected in his or her his representation dated 29/2/2025, a copy whereof avails at Annex 9. First, the essential grievance is as to non-payment of withheld salary, so-called,
so also the current salary.
and denial of current salary as well. First, counsel submits that no person can be asked to work without the payment of salary in view of mandate enacted in Article 23 of the Constitution of India as expansively interpreted by the apex court in state of Gujarat versus Hon'Ble High Court of Gujarat, 1996 or 1997, I do not know. Just look into that. First, in all fairness, he submits that if a direction is given to consider his representation in a time-bound way, his client will be happy. First, next paragraph. Learned AG appearing for the OPs very fairly.
OP number 1, 2, 3.
Very fairly submits the 2, 1, 2, and 3. 1, 2, and 3.
1, 2, and 3.
Very fairly submits that he would instruct a jurisdictional authority to look into the grievance of the petitioner in a time-bound way. If petitioner also cooperates in furnishing all necessary material required for that purpose. First up, he tells the court that some reasonable time be fixed and all contention be kept open. First up, with this proposal, counsel for the petitioner is agreeing. First up, in the above circumstances, 8 weeks.
Opposite party number 3, your lordship.
3 matter.
OP number 3 to consider, yes.
That is, my lord, year 1998 Supreme Court 3164.
Not 19.
That is state of Gujarat versus state High Court of Gujarat.
Be 97, something like that.
They say AR.
AR 1997 it must be. Cannot be 90 because I was in 90. I was only 1 year old at the class.
98. I am saying 98.
98. Okay.
Yes.
That's what.
That
AR 1998. SC. So and so.
3164.
3164. Yes.
Item 10.
Yes, sister.
Lordship, in this case, the petitioner is a retired government servant who has joined her LLB, 3-year LLB at Udistar Mishra Law College, which is the opposite party number 3, which comes under opposite party number 1, Madhusudan Law University. Lordship, what happened in this case is...
Declare LLB results.
Yes.
And
it has
issue
been
LLB graduation certificate.
Yes, it has been withheld. Yes, Your Lordship.
Issue emergent. Post immediately after service.
Item 11.
There for the disbursement of the salary in the training period, my lord.
During the
training period of
training period.
Yes, ma'am.
Even during the training period also salary is payable?
Yes.
Have you made representation?
No. Second time I will come, fine.
No, have they rejected your representation? Where is that?
Annexure 2, my lord.
Annexure 2?
No, my lord, Annexure 4.
4?
Yes, ma'am.
On what ground it is rejected?
Last line.
Mr. Behra, accept notice. Find objections. Short period matter. Issue emergent notice. Mr. Behra accepts notice for all OPs. First, call this matter in the second week of November since it lies in a very narrow compass. I will do the second round.
Item 12.
May I please, Lords?
Yes, sir.
The petitioner was appointed a lecturer in English, being a selection board candidate in the year 1920, my lord. While he was working as such, my lord, it was alleged that he remained absent from the college on 16/4/22 when the president of the governing body made a visit to the college.
One day.
For that, my lord, they did not release my salary for the month of May 2022. I made successive representation to the principal as well as the president of the governing body, who is having yielded no result. I approached the state government. The state government under Annex 15 at page 63, page 63, therefore directed to release the salary of Miss Priyadarshini, that petitioner.
At the earliest, within 3 days.
Within 3 days. They did not do. I approached your lordship. Your lordship said under Annex 16 that relevant portion is at page 60. No. To act in terms of the government order. Thereafter, I produced this order of your lordships. They have rejected by the impugn order.
On what ground?
On the ground that the government had asked them to initiate disciplinary proceeding, which is in the pipeline, and till disposal of the representation, which is yet to be initiated, salary cannot be paid. For last 3 years, I am not receiving my salary.
These things can happen in Alice in Wonderland. We had one great book.
My lords, it is not so simple what is submitted.
Anyway, you accept notice. I will call this matter in the first week of November. You punish him.
My lord.
But how can you withhold the salary?
My lord.
I don't understand.
So it is, she's not working, my lord.
She has, the government itself has said.
No, on this very same day, 2 letters were issued by the
inquiry. You are acting upon one letter, you are not acting upon another.
Our reply
selective.
Will file our reply.
But the college has withheld. How can you depend that order? You are not depending in the college.
No. Notice to go to the college.
You are right. Issue emergent notice. Mr. Mehra on request accepts notice for 1, 2, 4 and...
No, 1, 2 only.
No, sub-collector.
Please, the president of the governing body.
3, 4, 5, your lordship.
1, 2, 3, 4, 5 emergent notice. Post in the first week of November 2020. Very curious things are happening in state of Orissa. Yes.
Well, lot of litigations by the parties intersect.
That's all right.
You are a party to it also.
You should not antagonize him on the eve of the festival. Yes.
May please, Lordship.
Yes, sister.
My prayer question is page 12, my lord. That is disbursement of some period of gratuity, my and only
half months.
My lord. That only received the petitioner, my lord, the fixed gratuity amount, my lord, not for 7.5 months, my lord. That and unutilized surrender leave has not been disbursed.
Have you given representation at least?
Allocate the second round litigation, my lord.
Second round litigation. Issue emergent notice, Mr. Behera requested to accept notice for all OPs. All OPs? Yes, all OPs.
Controller of accounts.
All OPs. Controller also for you are appearing? Or there was some panel counsel for
No, controller of accounts.
You appear. Okay. Call in second week of November. Since matter lies in a narrow compass, and petitioner is in the second round of litigation.
Item 14.
What date?
It will come in the second week of November. Yes.
The material to our MSC after completion of 30 years service balance. Similar
covered by judgment. Covered by judgment.
Yes.
Give copy to brother also. Give it to Mr. Lenka. Yes, have you changed the factuals in that? By your
Only it is to be rounded up.
Same order.
Come on.
Same. Covered by judgment. Next.
Item 15.
The matter relating to grants of unutilized leave salary, gratuity amount.
Representation is pending.
Representation Annex 7 also. That was pending for the
petitioner's short prayer in the petition is as under. Next paragraph. Learned counsel for the petitioner submits, despite giving a representation dated 10/3/2025 and 27/3/2020. No, 10/3/2025. Comma. Nothing has been done in the matter, and therefore a direction be issued to the OPs to take a call on the representation in accordance with law and in a time bound one. First of all, learned AGA Mr. Lenka, in his usual fairness, submits that he would instruct the jurisdictional OP, which OP? OP number 1, to look into the grievance of the petitioner in terms of the representation in a time-bound way, if all contentions are kept open. First off, with this, counsel for the petitioner is agreeable. Next paragraph. 8 weeks, open to solicit. Now, no course. Okay.
Item 16.
Number 16 is transfer matter to a student notice of NP and MLA, similar matter.
Similar matters are there. Are you relieved already?
Not relieved.
Not relieved?
Not continuing same school.
What we have, what order we have made? There are 2 sets of orders now.
Issuing notice and granting stay in one hand.
If he is not relieved, then don't relieve him. But what will happen to the school there if other person is relieved?
Sir, petitioner is a headmaster, so no one came as a replace of headmaster, so he is not relieved.
Not yet relieved. Yeah. Issue emergent notice. Mr. Lenka, learned DG accepts notice for OP numbers. All OPs.
All OPs.
All OPs. First one. Same order.
All are same. All are same. All 3 are same.
Correct. All 3 are same. Similar order.
Item
But
17.
why you did not make a representation? Saying that no, you don't relieve me, you are doing it at the instance of MLA. In fact, this court has stayed so many orders. I will permit you to make representation. Until then, you will not be relieved. Let them take call on that. 1 week after the decision is communicated to you.
No, what happens, sir? They are not entertaining the representation.
He said that you will not be relieved now, till that is considered. Right now, that helps you. In all these petitions, the challenge is to the transfer order. All the same order, dated same, dated so and so. First, learned counsel for the petitioner that in a series of matters, this court has stayed and granted reprieve to the similar litigants. First, litigants. And therefore, the same should be extended to his clients also. First one. Next paragraph. Learned AGA Mr. Lenka appearing for the AGAs, appearing for the OPs, finds out that in a slew of matters like this, the petitioner, the litigants are relegated to the jurisdictional OPs in the light of Apex Court decision in Varadhara versus State of Karnataka. And therefore, the same course can be adopted here by reserving liberty to the petitioner to make an appropriate representation with supportive material. And if representations are made, the same would be considered in a time-bound way, keeping all the relevant factors in mind. First, this is absolutely fine. Brother, what I am doing is, I am staying the transfer. I am permitting to make a representation within 10 days. They should take call on those representations and inform you. Till then, the stay will continue. And it will continue 1 week after you are informed, because you have to make further, suppose if it is rejected, you have to come back here.
But
1 more week I will guarantee.
But one difficulty, this is, let's say, like other matters, as per recommendation of the local MLA MPs.
Therefore, I am doing this.
Grateful.
In fact, you are the first person to argue that matter and get stay.
Great person.
Yes. Alright? Excellent. With this proposal, counsel for the petitioner is agreeing. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioners to make appropriate representations within 10 days. And till a decision is taken, and also 1 week lapses after the same is communicated to the petitioners, the subject transfers of these petitioners is kept in abeyance. Ordered accordingly.
All are continuing lordship.
Say, yes. Therefore, I say, will say, it hardly needs to be stated that the petitioners shall be continued in the very same office if already they are not relieved.
They are continuing.
I am making that already. Till the task is accomplished. Okay.
If not relieved, should not be. I don't know what they are doing lordship.
Now they will
get lordship.
Okay, then that sentence, they will do that also. I know that. Yes. The last sentence shall be continued in the very same places in which they were working before the issuance of the impugnment. Otherwise, Mr. Swain, sometimes what they do, after hearing this, they will put
they are using the word deemed relief.
Deeming is also that.
Item 17.
One more week I have given to you.
Lordship, to come again.
Come again. This
second round.
I have invented that.
Yes.
And he will be interested that they will be encouraged to come.
You can file defamation suit against Mr. Mohanty now.
Yes. And will give opportunity to come second.
But I tell you one thing, in my court, all government counsel are effective and fair.
Very fair.
In one matter, the way Mr. Lenka argues.
Yes. In my matter, Loknath Behra.
No, in another matter.
Yes.
He surveyed entire law.
Yes.
And made a beautiful submission.
Yes.
Similarly, Behra yesterday.
Yes.
Behra he argued one heavy matter, taking up all possible contentions.
Yes. He has raised.
Yes. And you know him also.
Yes. He's a legal lordship.
Our Mohanty also.
Yes.
But one happy thing is, their head is on their shoulder.
Yes.
Yes.
May I please, Lord Sir? But the petitioners are the teaching and non-teaching staff of an aided high school. Well, they were favored with granting it with effect from 1/1/2006.
1/1/2004. Instead of 1/1/2006.
No, yes. Well, Your Lordship may kindly turn to Annexure 7 at page 24. On the application of the headmaster, the district education officer has recommended
1/1/2004.
Yes, to the director. Thereafter, Your Lordship may kindly turn to Annexure 9 at page 32. My Lord, the additional secretary to government, he wrote a letter to the director secondary education Odisha Bhubaneswar to examine the matter. Since the director has not submitted a report, therefore the matter is pending. And we have also made a representation to the state government, commissioner come secretary. Yes.
Let them consider.
Let them consider.
Kindly be seated.
Yes.
The short grievance of the petitioner is reflected in the prayer column as under. Learned counsel for the petitioner. Mr. Swain, I should address you as a learned senior advocate.
But I am not a senior, designated senior.
But I will teach you because the way you become with preparation and other things. Learned senior counsel, Mr. Swain, appearing for the petitioner, drawing attention of the court to the representation dated.
It is representation dated
12/2/2024.
24. Annexure 10
submits that despite some officials, some jurisdictional officials recommending the case of petitioner, after examining everything, no decision is taken by the statutory decision maker in terms of said representation. First, he also tells the court that the short grievance is the alteration of effective date of grant in aid. That is, it ought to have been 1/1/2004 instead of 1/6/2006. Therefore, he solicits intervention of writ court. Next paragraph. Mr. Lenka, what do you say?
Let it be.
Learned counsel AGA, Mr. Lenka, for a while resisting the petition, now submits that he would instruct the jurisdictional authority, namely OP number 1, to look into the grievance of the petitioner in the light of papers generated at the hands of the officials in a time-bound way, if all contentions are kept over. First, with this proposal, learned counsel counsel appearing for the petitioner is agreed. Next paragraph. 8 weeks open to solicit. Okay. Next.
Item 18. May I please, madam?
Yes.
The petitioner was appointed as a Hindi teacher on 25th of August 1992. The institution was notified as an aided educational institution on 20th of February 2004 for the prosperous block grant. And accordingly, the appointment of the petitioner was approved on 11th of October. Madam, what has happened? Petitioner was suspended by the opposite party number 3 without having jurisdiction. But thereafter, opposite party number 3, knowing that he has no jurisdiction, he himself wrote a letter to opposite party number 2, kindly reinstate the petitioner. After 4 years, the suspension was revoked, I was reinstated. Now, my lord, the 4 years period, neither I got my allowances, nor I get my salary. I approached the authority.
They are denying it.
They are not, my lord, they are not considering my.
No, you want quashing of an order.
Madam, because madam, they say, now in view of the departmental proceeding, which has not yet been initiated, you are reinstated.
No, without this is what I believe can be.
Madam, I've already seen now that if let notice go, now they have started proceeding.
What can?
No, madam, short date maybe.
Okay. Issue emergent notice. Mr. Lenka accepts notice for 1 to 3. Emergent notice to 4. Post immediately after service.
Madam, may I pendency at least consider my release of this case starting the bar.
Pendency of
during
petition does not come in the way of
release of
the jurisdictional OPs granting relief to the petitioner in accordance with.
Item 19.
May this please the court. The petitioner is a spinster and retired since February 2009. She is not able to get her medical leave, sanctioned medical leave and commuter leave salary. Lordship gets it in page 12 of the writ petition, my lord. They have admitted, they have sanctioned page 12.
Given representation dated 28 to 25.
Any representation in the crux of the matter is, Lordship kindly turn to page 12.
No, I am asking you, sir, now. Will you be satisfied if there is a direction is given to consider your representation, or I should direct notice to them, whichever way?
Let me present my material fee for Lordship, so then your Lordship, whatever Lordship wishes to do it kindly.
You tell me. I am giving an option to you.
They have given a sanction, my lord. There is particular leave sanction amount is specified in page 12.
Therefore, in terms of that, they should consider your representation.
I would make the disposal retired.
We have made it already. 28 February 2025. I will tell them to take this decision within 6 weeks. In accordance with law.
Right.
All contentions I will keep open. The prayer of the petitioner is short and sweet. And it is as like that. Next paragraph. Learned counsel appearing for the petitioner draws the attention of the court to the representation dated 28 to 2025. 28 to 25.
Yes, ma'am.
25. Wherein the request is made as an first. Counsel submits that if a direction is issued to consider the subject represented, kindly be seated. If a direction is issued to consider the said representation on a war footing in accordance with law, his client would be satisfied. First of all. With this proposal, learned counsel, Mr. AGA, Mr. Lenka is agreeable, subject to the caveat that all contentions of the party should be kept open. First of all, in the above circumstances, 6 weeks. Solid signature. Okay? After.
Item 20.
May I please, ma'am? I may permit you to place this case on behalf of Mr. Mahapatra, my lord.
You're most welcome.
My lord, pursuant to resolution dated 12/3/1996, Annex 1, the government invited applications on the.
Any representation is made?
Yes, that is Annex 12 series is there.
If I direct them to consider, will it help you?
Well, also may direct them.
I will direct them.
Yes, ma'am.
Petitioner has made the following prayers in the writ petition. First of all, learned counsel for the petitioner submits that before approaching this court, his client has made a representation dated, detailed representation dated 21/6/2024, producing a cartload of material for favorable consideration. And despite that, nothing has happened in the matter, and therefore, this court should intervene. First, next paragraph. Mr. Lenka, learned AGA appearing for the OPs, very fairly submits that the representation shall be considered by the jurisdictional authority, namely OP number?
OP number 2, my lord.
OP number 2.
2 and 3.
Keeping in view all aspects of the matter, provided that.
You also may say 2 and 3, my lord.
2 and 3. Amen. If contentions of the parties are kept open. 2 alone.
No, only 2 alone.
Only 2.
Because it will create.
In similar matters, we have directed 2.
Yes, ma'am.
First, with this proposal, this is appreciable. Next one, in the above circumstances,
my lord,
8 weeks.
My lord, may I suggest one thing, my lord?
Yes.
This point has already been decided by this honorable court in Annex.
Keeping in view
the decision of this honorable court as well the trial.
Which is that?
That is
Annex the decision line of this court in OJC number 9384 of 1997, decided on 1/12/2000. Correct?
Yes, my lord. Thereafter, Annex 8, 9 and 10, my lord.
A copy whereof is available at Annex 8 and
9 and 10, my lord.
Another
that is Annex 9 is the another order, my lord. Same day it has been disposed of. Page 83 starts from.
And also OJC number 4938 of 2000, disposed of on 1/12/2000.
Yes, my lord.
A copy whereof avails at Annex 10.
Along with the representation, I have also supplied those annexes.
I have said cartload.
Yes, okay.
Cartload of material is produced. Yes.
Item 21.
21, my lord, annexure 2, page 11 is pending before opposite party number 2.
Granting permission to sell the plot.
My lord, the fact of the case is
the 2 series. Who should take the decision?
Opposite party number 2, collector. Collector, madam.
Collector.
My lord.
Brother Mohanty.
My lord, they are made
permission to sell the property.
Because
take a call. Perfect.
Annexure 2.
Short grievance of the petitioner is as to long pendency of his representation dated
26/8/2025.
26/8/2025. a copy whereof will set annexure wherein he has sought for permission for alienation of property in question. First off, counsel for the petitioner submits. The competent authority being the collector, he ought to have taken a decision in the matter at least within a reasonable time. And that having not been done, this court should come to aid of the petitioner. First, next paragraph. Learned AGA Mr. Mohanty, on request appearing for the OPs, submits that the OPs are ex officio functionaries under various legislations, and therefore they will be under tremendous pressure of work on their shoulders. And maybe because of that, no decision is taken. There is delay in taking decision on the representations. First off, he assures the court that he would instruct OP number 2 to look into the subject representation in a time-bound way if all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In those circumstances, 6 weeks. 6 weeks.
Some more time because they have to verify the same. The stakeholders will be there.
8. We open to solicit information, etc. Okay.
Item 22.
Petitioner retired from service on attaining the age of.
This is in respect of that RSB matter, Ashok Mahapatra, which has been fixed. They have notice to be issued.
Similar to passed by this one court matter.
But notice is
representation is given. Representation is pending before the OP number 3 matter.
Have you changed the matter and other things?
Correct.
Annexure 3.
Annexure 3. OP number 3.
Yes.
Item 23.
Item 22, matter relates to, kindly see, while the petitioner was appointed as assistant teacher under Annexure 1, pursuant to the advertisement dated 24/10/1996, thereafter, which recruitment was held by the inspector of Hon'Ble, that was sought out for.
Amount should be deducted, credited to GPF.
Yes, thereafter, subsequently, thereafter, fraud was sought out. Thereafter, along with me, other candidates were also terminated from service. And in 2001 and in 2011, we were allowed to rejoin, my lord. Now they are stating that, but you are getting GPF deduction amount, my lord. That may not be deducted. So you follow that to submit that PRAN, under Annexure 6, page 23, kindly see.
That may not be corrected.
Pardon?
That may not be corrected. Yes, they can't do that.
Yes, ma'am.
There is one Gujarat.
My salary was withheld since July 2025, my lord.
You take emergent notice. Mr. Mohanty?
Yes, ma'am. They are saying since 96 they have been appointed by virtue of an advertisement.
Correct.
Subsequently, they have terminated.
Correct.
Subsequently, allowed to join in 2011.
Correct.
By that 2005.
What is that?
Who will attend it while in the counter?
In the second week of November 2025. Since matter lies in a narrow compass. Bring that Gujarat judgment.
Yes, ma'am. Yes. Salary may be released since July 2025.
Salary also not being released.
No, ma'am.
Petitioner submits that. Even the current salary is not being paid to the petitioner.
Since July 2020.
Since July 2025. First off, if that is true, it shakes conscience of the court. First off. Therefore, OP number?
OP number, my lord.
We should
block education officer.
OP number 4 is look into the grievance of the petitioner, subject to outcome of the petition. Okay.
Annexure 6 may be stayed, my lord.
6 to be stayed?
Yes, ma'am.
Why?
Otherwise, my lord, it will be infectious, my lord.
It is to be decided by filing.
It's decided. Yes.
Item 24.
Yes, my lord. Reacted upon.
Yes, your lordship. Earlier occasion I have approached your lordship by the necessary 6-page
caste certificate.
Yes, my lord. Your lordship has directed the collector to dispose of the appeal.
Yeah.
While disposing the appeal, your lordship, annexure 5,
Yeah.
page 42, your lordship.
Yes, I remember.
Yes, my lord. The ground he has taken that the ROR of the grandfather, which is
does not reflect
his caste.
Caste.
That ROR will reflect.
My lord, just one, your lordship, that is the right thing, your lordship.
My lord,
the decision is there. The revenue entry regarding caste, it does not contemplate rule 21 of the service settlement rule. That's why the court. Yes, my lord. That's why your lordship, I have cited the decision.
I am agreeable with you.
Yes, my lord. Case your lordship decided that there is not an entry at all, a legal entry at all.
Let him take notice.
Yes, that's one other thing, my lord. In this case, your lordship knows while going through the appeal, he has rejected the caste certificate of the father. He had
by he being a party.
The Act say only the committee has the power to cancel the caste certificate issued by the competent authority. He doesn't have jurisdiction at all. He's only an appellate sitting in the appeal, and that's why he's a member of the committee. Collector is one of the member of the committee. Another thing, lordship, because your lordship, the caste, the petition, the opinion number 2 is unable to, the petition number 2 is unable to have an admission, and because of the lack of caste certificate, can your lordship pray for a provisional caste certificate issued by the Tahsildar? Because minor is not considered according to your lordship, spirit your lordship is giving the direction, he is not considered that aspect. Caste certificate is with the father. Father caste certificate was there, he was there. The child is entitled.
You have said that twice, sir. You are only repeating.
I
don't need so much time to understand.
My content says the father of a certificate, the child is automatically comes only when it is cancelled by the competent authority. It has not been cancelled. So my prayer is that since the child is unable to take admission,
admission in what?
University, Navodaya Vidyalaya.
Navodaya Vidyalaya.
Lord, shall I have a prayer also in this case?
As it is seen from the appellate order, the confusion belongs to ST category or SC category.
Either way, he will be entitled to.
But if at all provisional certificate is considered whether it will come under the purview of SC or ST, that may create the.
Now, if the case were to be whether he is a reserved category or a general merit, I would have understood. Either way, either he is SC or SC. Either way, he is entitled.
Obviously, he will not come under your category. So they can give an undertaking also.
He will not come under UR.
No, he cannot come under UR.
If it were to be case of UR, I would
matter would have been something else. Matter would have been something else.
We will give interim relief to have made out a case.
They can give the undertaking also.
He will not take any.
They give the certificate, but
issue emergent notice. London DGA is requested to accept notice for 1-2. First, petitioner has moved an application in IA number 17206, 17206 of 2025, supported by an affidavit seeking grant of the free. First, counsel argues that in the light of Madhuri Party versus State of Maharashtra, 1994. Ordinarily, the caste of the child follows that of the father, and father's certificate having been unilaterally cancelled. There is great error apparent on the face of the record, and that has prejudiced the educational interest of the child petitioner. First, next, there is prima facie force in this submission. Next, what prayer you have done now?
My lord, your lordship, in this case, your lordship, provisional certificate is to be. Prayer is that the prayer that the honorable court is pleased to issuance of provisional certificate by opinion number 4 till the disposal of the deed. On the ground stated
In the above circumstances, would be number 4. We'll stay the case, cancellation of this one. In the above circumstances, the impugned orders is a stay coupled with a direction that the school authorities shall act upon the caste certificates in question for the purpose of admission.
Your lordship, the caste certificate will be issued by the opinion number 4, my lord, Tahsildar. Provisional certificate.
No, your father's caste certificate.
Yes, my.
Father's caste certificate for the purpose of admission. Okay. They could not have cancelled it without giving notice to father. Yes. One sentence you put into. This interim relief is granted, keeping in view the essential fact matrix of the case that petitioner either belongs to scheduled caste or to the scheduled tribe, comma, and not to unreserved category.
In previous case, I petition I have filed, my lord, for release of area, my lord, that may be acted.
Which one?
My lord says allowed for the present salary. So let that be decided after the final.
Area since 2024, my lord.
You have said that, but notice has to go.
And nothing remains to be adjudicated.
Current salary will be released.
Obviously, my lord has passed this order.
Since 2024 onwards, my lord, July 2025, my lord, that has not been released, my lord.
Therefore, I have directed them to look into the grievance.
Yes, my lord.
If your contention is...
my lord, that
no, nothing.
Nothing.
Yes, next. Let us see after service.
Item 25. May I please, your lordship?
Yes, sir.
The present petition is a lady teacher working in Navrampur district, Navrampur block in rural area. He faced the transfer order under Annexure 1 by the transfer level committee of the district with a 60 kilometer distance of a present place posting.
How many?
60 kilometer distance. Having no communication facility. Lady teacher, his husband also posted.
No convenience.
No convenience, well.
Which place to which place?
Place hoche Rathan Majiguda to
different blocks.
No buses to that place.
Convenience nine.
Navrampur.
There may not be a flight, I agree. But buses
are there. Buses are there.
That's all.
But convents and old parents with 6-year child.
How many children? How many?
One children. Your father-in-law, mother-in-law.
I have not asked question. You should keep quiet till the question is over. How many children your parents have?
One child.
Your parents have?
One parent, one child. One child. Son is also a teacher, different.
You are
daughter-in-law.
Daughter-in-law. Son is? Son, what son is doing?
Son teacher. I have an extra son
is also teacher.
Teacher. The
husband and wife both are teacher.
Father-in-law and mother-in-law and the minor child with residing in the house where the petitioner is residing. That's why made the grievance before the chairman of the committee.
Who is the chairman of the committee?
Collector OP number 3.
You take a decision till then don't leave. Same order which you have made. No?
Annexure 7.
Right now. The short grievance of the petitioner is against the transfer order dated
16/9/2025.
16/9/2025, whereby she has been transferred from X school to Y school. Right down the same side of that. First, counsel for the petitioner draws attention of the court to his client's representation dated 9/9/2025, presumably made in terms of the apex court decision in Varadhara versus State of Karnataka, and that the same has been kept in a cold storage.
It's only in the month of September.
This contention. And therefore, a decision has to be, therefore, a direction be issued to take a call on the subject representation in a bold way. Until decision is taken, the client be permitted to continue in the same place. Next paragraph. Learned AGA Mr. Mohanty, in his usual style, opposes the petition, citing the very same decision, saying that it is the duty of civil servants to go and report for duty wherever they are posted, and nobody is an exception to this. First off, having so contended, now he agrees to instruct OP number 4, 3 district level transfer to look into the grievance of the petitioner in terms of the representation in a time-bound way if all contentions are kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, this petition is disposed of 8 weeks. First off, till a decision is taken on the representation and a week lapses after its communication to the petitioner, she shall be continued in the very same place in which she has been working, if already not relieved.
And there is deeming relief. Deeming relief
shall be continued. All contentions are kept open.
Milord,
Open to solicit information.
Milord, one paragraph. It will look on me. The representation addressing to the collector. In fact, district level transfer committee has been added as OP number 3.
But collector happens to be the chairman.
Exactly. So that may be reflected to the district level transfer committee to consider his grievances. But it will be convenient for
it is made clear that the representation given to the collector shall be treated as having been given to the district level transfer committee, since he happens to be the chairman
of that committee.
He cannot go and give to every member of the committee. He has given it to chairman. Yes, sir. Is pulled on.
Item 26.
May I please announce? Lord, the competence of Puri Konarko Development Authority for initiating proceeding under Section 91, subsection 1 of the Odisha Development Authorities Act is under challenge before Lordships. Similar matter, Lordships have heard and posted to 9th of October. 9th of October. And 9th of October? Yes, 9th of October and issue emergent notice. Yesterday's
the list is there?
Yes, similar matters, my lord, I have given the list. Item 30 of yesterday's list.
Emergent notice.
Here, my lord, I am for 1. 2, 3 are separate and 4 is also separate.
2, 3 I have instruction to appear, my lord. I will file the Wakalatam.
3. 2 and 3. Emergent notice to 4 and 5. Call along with WP number.
My lord, I have also sought for interim.
Any interim order is granted?
Yes, in that
case, that
this application in IA number so and so supported by affidavit is moved seeking protection, interim protection. And counsel for the petitioner submits that such a protection has already been granted to other litigants, similarly circumstantial litigants, and therefore the same should not be denied to his client. First off, there is forth in the submission, which is that judgment of the apex court. When interim relief is granted to one set of litigants, it should be given to other set also.
Sorry, Manoj.
Arvind Srivastava.
Arvind Srivastava. Give that copy.
I will.
You get citation and bring that judgment.
Yes, Manoj.
You bring it only after judgment is brought. Otherwise,
yes,
not. Thank you. All of it. So I don't. Those circumstances, same protection have been afforded to the petitions against the insured action. Yes.
Item 27.
Item 27, my lord, I just got instruction from, this is an in-person petitioner matter.
In-person petitioner matter.
Dr. Abhishek Upadhyay, he, due to some rainfall and some personal problem, he requested me if I could kindly pass over it.
Pass over?
He is on the way.
No problem. Rains are coming in the way. Rain have some rain, na? Rains, go away. Little Johnny wants to play. Something like that. Yes.
This is a individual application. This is in respect to the PAR, performance appraisal report.
Performance appraisal report of which bar?
This is
It has two meanings. It has two meanings. Which bar?
PAR.
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 Okay. All right, pass on.
Highly obliged.
Or can we issue notice?
Because private party is there, unless without hearing him, the notice can be issued. For stay time, then 2 is to be notice to be issued.
Learned DGA, Mr. Monti accepts notice for OP numbers.
OP number 1 is for government and 2 is the private party.
Emergent notice to 2. Okay. In both the matters?
And no, my lord. No. Only one matter, 27.
Okay.
And no IA is there also.
Item 28.
May discuss petition seeking for lecturer group pay scale and reader scale, state scale mail. In the light of Loknath Pera case mail. Is covered by your lordship order.
You can.
I have corrected my lord.
You have corrected the dates, my lord. Different dates.
In third matter matter, connected third matter matter, only lords, connected third matter matter. WPC number 27886 matter. Permitted to file a fresh representation.
27886. Permitted to be withdrawn.
No, would not on withdrawn matter. Only make a fresh representation. This is there.
Fresh representation. Yeah, this order also we have a similar order na, in the light of that Loknath Behra.
Yes, madam.
28th. Okay. Yes.
Item 29.
May I please, lordship?
Yes.
But here, lordship, the trust registered in the year 2011, and lordship granted permission by the opposite parties to open a self-financing study, lordship, and still 2011 it is continuing, lordship. But the developments, lordship, in the 2012, 2 of the members, lordship, on the president and other members resigned from the lordship trust, and that is available under Annexure 2 and 3, lordship. One is my registered lordship, and Annexure 2, one Prasant Kumar Joshi, another is Kranti lordship. Both resigned, and their resignation was accepted, lordship. In the now recent development, lordship, in the 2023 new trust lordship by of amendment, lordship, they have lordship formed a new trust, lordship. It is still continuing after lordship subsequent developments, lordship. But lordship, cause of action, lordship, kindly see state, lordship, kindly come to page Annexure 5, page 67. Because lordship, page 67, Annexure 5, lordship.
Reconstituted.
Lordship. It is lordship, under this rule 25 of the Orissa Education, that is lordship, education, establishment, recognition and management of private junior colleges or higher secondary schools, rules 1991. 25 gives power, lordship, reconstitution of the governing body. But lordship, is a letter from the regional director to me, lordship, to my trust, lordship.
The reconstitution is perfect.
No, the reconstitution not in order, lordship.
Not in order.
Not in order. Lordship, last line only.
It's not made in accordance with rules. What is not made in accordance with rules? Which rule is violated?
Which lordship, that this they're referring to rules, lordship. That is the Orissa Education, Establishment, Recognition and Management of Private Junior Colleges, Higher Secondary Schools, rules 1991.
Which rule?
Rule 25, lordship, speaks of reconstitution of the governing body. Rule 25, lordship.
At least he should have said that anyway.
No, lordship, my case is something different. Just I'm giving the facts of the case, lordship. Okay. Because lordship, can you say 25, lordship? For a moment, it will be lordship 25 provides lordship. It gives a hand to the private, this charitable trust, lordship. How it will be formed?
Reconstitution of the governing body.
Governing body, lordship. And provides lordship speaks of the charitable trust, lordship.
No person shall be secretary for more than 2 terms, etc. Outgoing governing body charitable trust does not pass a resolution nominating members direct resolution. The outgoing president shall then furnish the director his approval. Shall be competent to substitute any name in the proposed governing body.
Lordship.
Director can do that.
Director can do that, Lordship.
But he shall consult the outgoing governing
body.
Now, what you want?
Lordship, what happened? Lordship, can Annexure 5, Lordship, gives letter on 67 on 9/4/24. The next page, Lordship, he gives same letter both to the president and the principal of the institution, Lordship.
Yeah.
And I responded, Lordship. I have responded. That is their Lordship. But Lordship, I am the president. Now the chairman has come to Lordship before Lordship. The entire trust is now before Lordship. Referring the chairman. But the president replied, Lordship. The president is my mother, Lordship. I am the chairman of the Lordship. So Annexure 6, what mischief they have planned, Lordship, kindly come to page 61. This is the mischief, Lordship, page 69. Annexure 7, page 69.
69.
9, Lordship.
3 photographs are there.
Lordship, those persons who have been given resignation since 2012-13, by 2012 and 13, and the resignation were accepted, Lordship, in 2024, after this letter, they produce a resident date before the Lordship resident officer.
If they are continuing that.
They revoke the Lordship resignation. Lordship, first paragraph is sufficed, Lordship, first paragraph. Deed of appointment of made this on 18 to 24 between Sri Prasanna Kumar Joshi as a such and such, the chairman as by the caste Brahmin, by profession social such and such Lordship, by the Hindu of occupation service, by National Indian, the authorized shelter trust was requested to revoke his resignation and to revive the Mahamaneshwari Educational and Charitable Trust, Mahaling. A general meeting was held in this regard among the general public Kahandi, a Nuapada and the parents of staff of Degree Science College, but did. Lordship, who has been resigned in Annexure 2, Lordship, kindly see, they have been given resignation since 2011 and 12 and 13. Now, Lordship.
Brother, how can a resignation which is accepted decade ago can be revoked?
Not the copy of the rate petition.
They are not given copy of the rate petition.
In fact, Lordship, it is settlement purpose. Without filing a copy, a matter cannot be listed. My brother
received it, Lordship. But the rule requires unless that is given. He cannot post the matter.
He can refer my copy also, Lordship. He can
not available.
Now, what is that? The interim order you have?
Lordship, now, Lordship, kindly see Annexure 8.
This happened when?
This letter was, Lordship, after the letter issuance of.
On which date all this happened?
Lordship, that is a Lordship happened, Lordship, on that is on 18/6/2024. After issuance of this letter, after issuance of the authorities know that I am the president, they have given this letter to me. After 2 months, this letter comes, Lordship. Now, Lordship, in pursuant to this recommendation, Lordship, kindly come to Annexure 8. Annexure 8, they have approved, Lordship. And page 85.
Annexure 8 is also dated 13/11/20.
Yes, Lordship.
But how can I give interim order now at this length of time?
Because of Lordship, kindly come to Lordship Annexure 11/13. I collect all the documents, which I am unable to get his documents, and a series of inquiries going on. Lordship, kindly come to Annexure 14.
Emergent notice.
Lordship.
Because much time has lapsed. What all has happened, I do not know. Only after the other side enters, I will be able to know. Therefore, at this stage, I will not grant interim order. I will sign the emergent notice on mail matter and the interim order.
Lordship, 107 page, Lordship, 107 for a moment. Why people, Lordship, what is the situation, Lordship, kindly see. Lordship, it is a report, a person to my application. It contains, Lordship, inquiries going on. And this is the report of the Lordship, the regional director. And Lordship, page starts from 103.
Everything all right. I fully agree. But at this length of time, how many months have happened? More than a year and
my humble submission, Lordship, collector can take care of, Lordship, because Lordship, collector can take care of all those issues. He can.
You take emergent notice, but let it come before the court immediately after service. You may custody also.
Only, Lordship, that's true. I am not trying to. Lordship, only say, Lordship, collector will. Only, Lordship, what's the situation, Lordship? Collector, Lordship, because they are taking a course of rupees by taking fake admission, and I am under, Lordship, I am there, Lordship, with the trust members are there. They are getting admission of 800 students, Lordship.
Issue emergent notice. Learned AG is requested to accept notice for 1 to 5. 1 to 5. First off, emergent notice to 6 and 7. First off. Learned counsel appearing for the petitioner, taking the court through the case papers, vehemently submits that there is eminent need for granting interim relief as prayed for in the subject application in IA number so and so supported by an affidavit. First. Since much time has lapsed after the happening of impugned action, at this stage, no interim relief as has been prayed can be granted. No relief as has been prayed for can be granted without hearing the others. First. However, the counsel for the petitioner is more than justified in telling the court that the collector should keep an eye on the affairs of the institution in question till next date of election. Not till. Let him keep an eye on the affairs of the institution. And for that purpose, he will have full powers. I have said them to keep an eye on also, will have full powers.
Lordship, only
post immediately after.
Lordship, can I take special measures to all the opposite so that at that
in addition to taking usual steps, it is open to the petitioner to take the stay.
Lordship,
two private respondents.
Lordship, 1 to 5 and 8, 9, Lordship, perhaps statement. Both are IAC.
AGA for 1, 2,
5 and 8 and 9, Lordship.
No, 3 also, regional director of education.
1 to 5, Lordship.
1 to 5.
1 to 5 and 8 and 9, Lordship.
8 and 9 also.
IAC, Lordship. This was
8 and 9.
Lordship.
1 to 5 and 8 and 9.
9.
Emergent notice to 6, 7, 10 and 11.
10 to 19, Lordship. 10 to 19.
10 to 19.
I made all the members my party, Lordship. Lordship. Grateful, Lordship.
Item 30.
Yes.
Please, Your Lordship. Annexure 6 is under challenge now. And the facts of the case are as such.
Why she is not audible?
And the Annexure 6 is under challenge.
Pull that mic also. You need 2 mics.
I'll be moved here, madam. The Annexure 6 is under challenge.
Here, 6 is under challenge,
madam. That is at page number 37, madam. But the facts of the case are as such. The present petitioners are a group of residents, my lord, in Utkal Realtors. It is a housing area, my lord. So these petitioners had by this Annexure 6, a enhancement of maintenance charges was served on these petitioners. That enhancement charges will be from 2.10 rupees per square feet to 2.50. But prior to that, there is already a dispute going on between these realtors and these promoters and the house owners, my lord. The dispute is pertaining that even though they have been given possession of the said apartments, but they have not given the occupancy certificate, and also there were a lot of deviations in the plan from the actual plan, and that was served to them. Regarding that, they made a representation to the BDA authority, my lord, because BDA is the appropriate authority who gives the planning sanction, my lord. After since BDA did not take action on that representation for a lot of time, we approached this honorable court. After the direction of this honorable court and subsequent reminders, finally BDA considered the representation, made and passed the order, my lord. That order rejecting our claim. We challenge that before the appellate authority, that is the Secretary, Housing and Urban Development Department.
What he said?
It is pending, still pending. And even for the disposal of that appeal, we again came to this honorable court, my lord. This honorable court directed that within 6 months dispose of the appeal.
He is not disposed.
Not disposed. We filed a contempt. Contempt is pending, in that notice has been issued. In the meantime, while the dispute is before the appellate authority, the realtors have served us another notice that from September you will pay more for the maintenance charges, when the very issue of maintenance charges and the occupancy certificate is under challenge before the appellate authority.
No, but you should make application there only.
Well,
in the pending appeal.
We'll make application. In the meantime, they
direct him to consider, take up that application if you make one.
After that also we have made an application, my lord. We have made that at Annexure 8. We have made an application to the BDA authority. We have also made an application to the realtors that since the dispute between you and us are pending before the year, so we can't comply with this order at this point of time. But that application has not been considered.
I will direct them to consider that. The short grievance of the petitioners is as to non-consideration of their applications dated
19/8/2025.
19/8/2025 at
Annexure 7, my lord.
7 and
Annexure 8.
Dated
10/9/2025.
10/9/2025 at Annexure 8. Essentially addressed to Bhubaneswar Development Authority and also to the Appellate Authority. No,
Bhubaneswar
Development Authority. First, learned counsel for the petitioner submits that if a direction is issued for the earliest disposal of the said application, his client would be satisfied. First term. In view of the above, the petition is disposed of, directing consideration of the subject applications on a work routine and preferably within a period of 2 months. First of all, contentions are kept. Registry to send a copy of this order to OP numbers. All OPs, all OPs by speed post immediate. I'll be back in minutes.
Okay, one more prayer, my lord. In the meantime, Annexure 6, pursuant to Annexure 6, no coercive action may be taken against us.
No, it is for them to locate. Otherwise, they may take coercive action.
They may ask us to pay the enhanced fee, my lord.
Till a decision, but if I make that order, then notice has to go to them. Instead of that, you take this order. That may help you. Okay.
Item 30, small 7. I may be given liberty to move an interim application before the appellate authority.
It is open to the petitioner to move any application for the grant of urgent relief at the hands of OP number. Appellate authority. One appellate hands of OP number 1. OP number 1. In that connection, all contentions are kept. Item 48. That's student. Students matter. Yes, come on.
My lord, have put me the only question because that re-evaluation I want, I have applied for 2 inadvertently or some mistake he could not apply for other questions. I have applied. My lord, have put me the question when we have applied, when you have received the.
You have not applied for re-evaluation at all.
Yes, I have applied. Yes, applied. I have got the answer script.
Correct, but you in respect of only question.
Only yes.
You have not applied for.
I have only applied 2 questions in 3 subjects.
Yeah. For that they have done
re-evaluation. I have no quarrel against them. I have no grievance against them. Only I pray before my lord. If they will consider the other question what I have now prayed for.
What are you allowed for
that my
evaluation?
They will have their own examiners. I have no issue.
No, question is not that. Within what period you may apply for evaluation?
In time. That I have given kindly see. Dates.
In time in respect of other questions.
Yes, other questions.
You have applied for other questions?
Yes.
Applied at all?
No, other questions I have applied. They have given they have given. Kindly see the dates. Para 3 I have given.
That in the hearing, the court was ready to know the date of application submitted better for revelation of the answer, date of application deposited for the scanned copies of answer slips, and the date of service. Previously regarding the court result, the petitioner has made an online application 26/5/25 to obtain and copy of the original. This depositing the login file. CBS facilitated a password to the petitioner to obtain the scanned copy of the answer. To receive answer slips and online made on 6/6/2020. Accordingly, same day petitioner downloaded. On verification of the answer, the petitioner has put forth his claim for the application number so and so on 8/6/2020. Question numbers 20 and 27.
Yes.
as against the roll number so and so for question numbers 20 and 27 the subject mathematics. So the result of which was made available to the petitioner. This one is true. The only substance for the scrutiny of the answers with the help of the feature. I found that he has not been awarded appropriate marks as against question number 6, 9, so and so in the chemistry. Similarly, the subject is so and so. And the subject mathematics also has not been awarded appropriate marks against the correct answers for question. Proceedings only submitted in the petitioner could not raise the objection to those answers in his application. So he is raising the objection that further evaluation is. Further evaluation.
That only I prepared before my lord. That was quite impossible. No, this is only possible if my lord will indulge. Otherwise, it cannot be. Because that is the. Because what I beg to submit, my lord. Because in a hurry, he has submitted only 2 questions that I have stated well. What happened? Because the answer script was made available to him, he found these are the discrepancies. So I only pray, my lord, if they will, it is a request or court. But how can it be? Only, my lord, because that will not cause any prejudice to other parties.
That will be right. Once I give that right,
I may be penalized for this also by depositing the necessary fees that they will incur. Otherwise, my lord, the career of the students, the only thing they will do can be done with the teachers of their choice.
No, question is not that. After the cutoff date, where is the question of revaluation? Revaluation will have lot many consequences. They have to alter the ranking, they have to alter adults, etc. Many things will happen.
It will happen, fairly speaking, he has failed in that subject mathematics. That is the only, he will not get any medal, it will not, only if you...
The question is not,
it will do something, he has, but fortunately he has scored in the Birit Pilani. He has scored there, he got a rank. Only that part I will consider.
You have not made application for evaluation of other questions.
Other question I am not, that is my case.
Cannot seek
that is my case. Only because it is before the my lord, only that much indulgence.
My lords, fairly stating, that whole thing, what we praise for, will make the whole system topsy-turvy. Rightly said by your lordships, that ranking, that marking, and another examiner, his availability.
And others will come.
Others will come.
So if you are given relief to Mr. Dash only because he is your friend, they will say, why not us, sir?
No, there are certain unpleasant things which I don't want to say, because not that I'm deliberately talking tongue-in-cheek about the petitioner, but the first attempt he has failed, second attempt he has failed. Now, under the rules, 3 compartmentals, he has already availed 2 compartmentals, he has failed. So that unpleasantness I don't want to be discussed. But system will be totally topsy-turvy, my lords.
Go to the 3rd column.
And one thing that I would like to bring to your lordship notice, that date also, which he has mentioned about the application, could not be, because our last cutoff date was 5/6. How could it be 8/6? That has to be verified from my clients also. But at the outset, I would like to say, in my annexure, page 16, the cutoff date is before your lordship. Cutoff date is 5/6, 31/5/2025 Saturday to 5/6/2025. Now he comes up with a date which is 8/6/2025. How could that be?
Anyway, that is the date they have received, my lords, and they have supplied the answer script. That is the answer script I am filing along with my writ petition. Those answer scripts are there with before.
Petitioner student has coined his prayer in the petition as under. Next paragraph. Certain information was sought for from the petitioner as to whether he had applied for revaluation of certain subjects and on which the same was applied for. First of all, counsel for the petitioner has filed the additional affidavit of his client dated 28/9/25.
I have shown the affidavit. My lord, today I have filed. Yesterday I have shown the affidavit. I have given the copy to my learned friend. I was offering it because my lord had said, keep it with you. Tomorrow you will place it. I filed it today.
No, what is the date?
Not given.
Here, 2 days already has advanced. What is the last date? Today is what is the date?
Today is 26th. 26th.
Right, yesterday on 28th. 28/9.
Cloth has done, and I have not seen that. Don't you carry it. Yesterday it was shown.
First off, for ease of understanding the material dates and events, the full affidavit is reproduced. Reproduction. Full affidavit should be reproduced. Okay. Next one. Learned counsel for the petitioner vehemently argues that after receiving copies of his answer scripts, he could make the decision as to whether he should go for revaluation of certain answers which were not applied for revaluation earlier, and therefore he made the decision to go for revaluation accordingly. Although no application for such valuation formally was made. First of all, this is reflected in the affidavit also. Next paragraph. Learned senior panel counsel, Mr. Pattanayak, appearing for the answering officer, submits that revaluation, if permitted under the extant rules, only then can be sought for. Semicolon. Accordingly, the petitioner had sought for revaluation of certain subjects, certain answers, and that revaluation admittedly has been accomplished. Sorry. The answers in respect of other subjects which were not requested for revaluation cannot be ordered to be revalued by this court.
Other question, madam. Subject is the same question.
Correct. Other answers to
other subject,
other subjects. No, other questions question. In other subjects.
Same subject.
Same subject.
Same subject.
Answers to other questions in the same subject. Should say that. Yeah. Okay. It has been the consistent view of the apex court that next paragraph. Having heard the counsel for the parties and having perused the petition papers, this court declines indulgence in the matter in as much as it has been the consistent view of the apex court that unless a revaluation right is granted and exercised in time, Great Court should not grant indulgence. In as much as that would open up floodgates of litigations, as rightly submitted by learned panel counsel appearing for the answering notice. First, in this case, admittedly, although subject is same, the questions, the answers were not sought for revaluation at all. Although other answers were sought for such revaluation. First one, in the above circumstances, petition being devoid of merits is liable to be dismissed, and accordingly it is, courts having been made easy.
Your Lordship may kindly observe that
Mr. Will you get the date altered? It's 26.
It might not come there, right? Yes.
Don't mention date. That sometimes in a hurry it happens.
Shall I correct it now?
No, you cannot.
Yes.
No problem.
My lord, since there was a judicial order of production, your lordship may have to say that it was.
Before parting with this case, the court appreciates the efforts made by Mr. Pattanaik, the panel counsel appearing for the OPs, in securing the answer sheets for the perusal of this court. First off, that's sufficient. That will look on.
Item 31.
Yes, your lordship. Petitioner is a lady teacher. Your voice is not. You are very tall, I agree. But you have to grab the mic also. Make it taller.
It is not in my size. I have to go down for that.
Yes.
One of the petitioner, next 1, your lordship, page 9. The petitioner was put to transfer from Basipita to Devolodi in the district of Moyurbhanj, my lord. Teacher, my lord. That is after the cut of that. Serial number 3, the Sobhana Das.
You make a representation. I will protect you from transfer.
Yes.
Till decision is taken.
Yes.
In terms of Vadodara versus so and so.
Yes.
And I will grant you 1 more week. After decision is communicated to you, they will not disturb you for 1 more week.
Yes.
So that you can come back.
Yes, my prayer is on that.
Petitioner is knocking at the doors of High Court with the prayer scripted as under. Essential grievance of the petitioner is against the office order dated 18/9/2025, whereby he has been transferred from X school to Y school. Just try to give the next paragraph.
Transfer. They are saying that you take classes, sending me one school to another within 3 months.
They get there back to the previous school.
Back to the previous school. They send one school, thereafter they take back me to the original school. The original transfer order is also after the cut-off date of the 15th.
7/7/25.
Yes, my lord.
But you have made a representation now.
No, I have made representation. My lord, fresh representation I have to.
Counsel for the petitioner submits that if liberty is granted, he is going to make a fresh representation in the light of decision of the apex court in Vadodara versus state of Karnataka, so and so. And a direction be issued to consider the same in accordance with law. First, he also tells the court in similar matters, this court has adopted the same course, keeping in view the decision cited. First. Next paragraph. Learned the ASC on request accepting notice from the OPs very fairly agrees with this proposal. However, he enters a caveat that all contentions of the parties be kept open so that the meritorious decision can be taken by the jurisdictional authority. First, this is absolutely fair. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a representation within 10 days. And if one is made, the authority shall take a decision thereon within 2 weeks next following. All right? Till then, what should happen?
Till then, no coercive.
Till then, no coercive action pursuant to impugned order will be taken against the petitioner.
Oblige.
Item 32.
It may please your lordship, my lord.
Yes.
My lord, the petitioner retired as principal of Panchayat College, Hon'Ble in the district of Baud on 31/7/2024, my lord. She submitted her pension papers on
pension and dispersal.
My lord, my lord, here what happened, my lord? This Honorable Court directed the director to take a decision, my lord. Pursuant to the direction, a notice was issued me to appear on 9/7/2025 before the director. I appeared. The principal, present principal, who was the contestant and filed the petition against me to be a principal of that college, my lord. He did not appear, my lord. That matter was adjourned. To the adjourned, my lord. Next date on 13/8/2025 date was fixed, it was not communicated to me, my lord. The director, without communicating the date, my lord, and hearing the principal, passed an order under Annex 15, my lord, directing to recover 25,900 from me, my lord. You lordship kindly come to page 55, my lord.
On what ground?
My lord, that advance was given, it was shown in the audit that the advance amount of 25,900 has not been complied with, my lord.
Yes.
My lord, your lordship kindly come to Annex 6, my lord, 16, my lord, at page 57, my lord.
57?
57, my lord. My lord, that 25,900 was taken advance by Kishore Chand Jagdev, lecturer in Odia, who was the, my lord, career counseling programmer. The audit report, next page I have annexed at page 58, my lord. 14,900, 11,000, total 25,900 taken by the KC Jagdev, my lord. Well, this has been reflected in the next date was recovered. That was recovered in the subsequent audit report. That has been recovered. Now again it has been directed in order to recover it.
Yes, brother. You want to recover twice, sir?
No, my lord, that apart, my lord. Lordship kindly have a glance to page 54, my lord.
Yes.
Lord, while the petitioner is in charge of the principal, he submitted his pension papers alone, my lord. Suppressing the fact that Lordship kindly have immediately, accordingly, in third paragraph,
yes,
some important files and documents of the college have not been handed over to the principal at the time of superannuation.
No, that we will look into after notice. But how can you recover? Because what is the traffic massing? Traffic massing says.
That has been recovered. Audit showed that it has been recovered.
Recovered also. Your audit report says that it has been recovered.
But you lost the kind, come to page 76. Audit report shows it has been recovered.
What is it? You are wasting time. Your time. I have a lot of time. Okay. Issue emergent notice. Learned AGA on request accepts notice for OP numbers 1 and 2. Emergent notice to OP3. Yes, OP3. Next one. Petitioner has moved an application in IA number so and so, supported by affidavit, seeking the reprieve at the hand of this court against the recovery in question. First off, he points out from the audit report that question of recovery would not arise because he has already remitted the money back. First off, he further submits that because of Apex condition in Rafiq Masi, 2014. So
this is made for only class 3,
class 3, but anyway, we have extended it to others also. Later. In view of sign. So no recovery, even otherwise no recovery can be made. First off, there is some force in this submission. First off, matter requires deeper examination. First off, in view of the above, the application having been favored, the impugned recovery is kept under suspended animation. Okay.
My lord, I pray one thing. 49 item, that teacher who has leg has been septic, my lord, may be taken up today, my lord.
49.
49.
We'll take that. We'll reach perhaps early. Today, no court, no many advocates.
You will also specifically yesterday fixed today.
That's one. That's one. Anyway, the court is absolutely, today, there are no advocates at all. Yes.
Item 33.
Pursuant to the opposite party is inviting application from the intending candidate for the post of junior teacher. Accordingly, the petition was replied, and she also qualified in the all list test suits. The lordship kindly glance on page 79. Annex 11.
Did you make any representation?
Lordship, then Annex 12 is my representation.
If they consider, will you be happy? Lordship. Right on. Correction of gender in the final merit list.
Lordship.
They have shown you as what?
They have shown as a male instead of female.
The short grievance of the petitioner is as to reflecting the gender as male when she is female, when it is female. First up. For correction, petitioner has made a representation dated 10/1/2024 a copy whereof avails at Annexure 12 series. First off, learned counsel for the petitioner submits, unless this court intervenes in the matter, comma, even small errors like this also will not be corrected by the jurisdictional authorities. First off, there is a ring of truth in this submission, since such cases are seen by this court day in and day out. First, next paragraph. Learned ASC appearing for the OPs very fairly submits that he would instruct OP number 4 to look into the grievance of the petitioner immediately if petitioner also cooperates by furnishing necessary records. First off, he puts a caveat that all contention should be kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next person, in the above circumstances, petition is disposed of 6 weeks. Okay. Open to solicit.
I think the proposal have been withdrawn.
Okay.
Item 36.
Lordship, item 36 may kindly be passed over.
Passed over?
Lordship.
What is this matter about?
Your Lordship, this matter, any application for amendment, Your Lordship.
Amendment application will allow.
Lordship, what has happened in the meantime is this is a hospital which is functioning under a registrable charitable trust. So this hospital, there is a scheme actually which has been floated by the outgoing government. Now this scheme has changed. Outgoing government, the scheme which has been floated was BSKY, Biju Swasthya Kalyan Yojana scheme. Now this the new scheme has been enacted in the month of April 2025, which is Your Lordship, which is renamed as Ayushman Bharat Pradhan Mantri Jan Arogya Yojana Gopabandhu Jan Arogya Yojana. This is the scheme which has been floated. The scheme speaks of, Your Lordship, outlines about the benefit of the poor people who are attending the treatments, in the hospital, their expenses, hospital expense benefits, post-hospitalization expense benefits, daycare treatment, Your Lordship. Now, in the REIT application, we have asserted that they have not provided the benefit of BSKY as there was an agreement. That agreement was concluded, then they did not extend their benefit. So we came to the court and the court protected us. On 8/10/2024, the court protected us by providing an interim order. Now we have filed this amendment application as IA number 15962 of 2025, which is at, Your Lordship, flag A. Flag B, Your Lordship, flag B. As well as IA number 15963 at flag C for stay.
Why can't you file a comprehensive petition?
Your Lordship, the REIT application which has been filed in the BSKY scheme, in that scheme, the authorities, the same authorities are there.
Yeah.
They said that we are not going to extend the benefit. So if they are not going to extend it, now the scheme has changed. If at all I file this REIT application, there would be no cause of action to file this REIT application, because the only thing is the BSKY and ABJP scheme has been changed, Your Lordship. The benefits are same for the poor and downtrodden people.
When the application was served on the other side?
Sure. On 12/9/2025, Your Lordship.
Where have you served?
I filed an IA application.
Any copy served on it?
No. Copy is not. Your Lordship, may pass it over and serve it, Your Lordship.
You serve it and they will file objection, then we can consider it's amendment.
Your Lordship, the scheme is the scheme.
Right. They are entitled to file objection. Can I allow if it is at the admission stage, I would have done that.
Your Lordship.
After notice in a pending matter, you have moved the application.
Your Lordship.
So naturally, other side should know.
Then, Your Lordship, I may pray that it may be passed over. Mr. Sujya, my learned senior, is on his legs, Your Lordship. Kindly pass over.
Fine, bring. Pass.
ସେଇଆ ତ ହବ, କପିଟା ଦେଇଦେଲେ ତ ସରିଯାଉ ନା, ଯାହାପରେ ଆସିବ
ବନ୍ଦ କରିଦେବେ ଯଦି. My predicament is, Your Lordship.
Predicament is serve copy.
Your Lordship,
you take his predicament. You are telling only about your predicament.
ଆପଣ କପିଟା ଦେଇ ଦିଅନ୍ତୁ ଛୁଟି ପରେ ଆସୁ ମୁଁ ଅବଜେକ୍ସନ ଦେଇଦେବି ମ୍ୟାଟର ୱିଲ୍ ବି ଏଣ୍ଡ
Pass.
Item 38.
Item 38, my lord, covered by the that university DDC matter, direct distance education. My lords have already given.
Covered by judgment.
Covered by my lord. It is Litun Pradhan 19
The subject matter of this petition. You have changed everything now.
My lord.
In this way, it should be done.
My lord.
Okay.
కేసు పుడుచుకుపోయి ఫైల్ దేఖేను
Hello.
Item 39.
May it please your lordship. Lordship, in this case, the petitioner is a BLLB honors 5-year integrated law graduate of the batch 2014 to 2019. The petitioner had few back papers, your lordship, which she was allowed to appear and clear by the virtue of this honorable court's order, wide annexure 1, page number 9, your lordship, under the Sarva Khyama Yojana. There are basically, your lordship, 5 petitioners in this case. The petitioner number 2 is the current petitioner, Anushri Pradhan. In her case, what happened is the course duration they have made 7 years, 2014 to 2021. It is reflected in a mark sheet. Whereas the other petitioner's mark sheet reflect 5-year duration, which is the actual duration. I have given it under annexure 5 series, your lordship, page number 17. Anushri Pradhan's registered number is 6159 by 2014, indicating that she belongs to the batch of 2014. And her examination year, passing year is 2021, held on 2021 month of June. So they have made it 7 years. Whereas I have given annexure 4, your lordship, kindly peruse page number 15. I have given the legible copy of it. There it is written 10th semester examination 2020 and the registration number is 562002 by 15, indicating it is a 5-year course, 2015 to 2020. So there has been a discrimination, your lordship, and even she has given representations to the opposite party number 2 to consider her case. But the opposite party number 3 wide annexure 7 has rejected it.
But you are permitted to appear in special examination.
No, your lordship, that was back paper examination. Now her mark sheet reflects that she has completed the course in 7 years. That is my...
So.
No, your lordship. Every other student who appeared under that Yojana, they cleared, their mark sheet reflects that they have cleared the examination in 5 years. Only mine reflects that.
1 second.
Yes, your lordship.
After one sentence, there should be at least comma, if not semicolon.
Yes, your lordship.
Is it done? Now, kindly come to page 20.
20, your lordship. Yes.
You are holding 20?
Yes.
Yeah. Go to para 2.
Yes, your lordship.
As per approval of syndicate, the petitioner was allowed to appear in a special examination 20 and 2021 under Sarva
Khyama
Yojana and also passed under this scheme. As per rules, the mark sheet and provisional certificate shall be issued after completion of the final exam. As such, the certificate and mark sheets have been issued to the candidate after clearing all back papers in 2021. How many years you took to clear the papers?
Lordship, 5 years. The duration of
Duration of the course is 5.
5 years.
Understood.
Yes, your lordship.
Then thereafter, how many years you took?
Lordship, they were not allowed to appear the back paper exams.
A question.
7 years, your lordship.
You took 7.
7 years.
They have mentioned that you have completed the course after 7 years. They have told the truth. Satyameva jayate.
No, lordship.
What is that you are saying?
Yes, lordship, the issue is the other students who appear under the same Yojana who are also petitioners. They have mentioned 5 years. Mine
is wrong.
Yes, just minus 7 years.
No, because you have completed after 7 years.
They have also completed 7 years.
That may be wrong. You have to show two things.
Yes, Your Lordship.
What has been done to others is in accordance with law. And therefore, I should be given the parity.
Yes, Your Lordship.
If what is given to others is wrong, you can't say, in my case also wrong should be duplicated. That's the idea of equality, parity. At least there are 2-3 judgments of the apex court.
Lordship, under the same Yojana.
You have said that.
Yes.
You are only repeating,
Yes.
I am also repeating. It is a 5-year course.
Yes.
You did not complete it in 5 years.
Yes.
You had a backlog. You cleared them after 2 years. So you took 7 years. If somebody takes over 15 years, they will write, this person has passed after 15 years. So that your credential should be known. Tomorrow, your client may become a judge, may become a minister, may become so many things. People should know how you did in your campus life.
Right.
They have reflected it. What is wrong in? After all, Satyameva Jayate. This is what you are reading, right?
Lordship, may kindly come to annexure 4, Your Lordship, page number 15.
Yes.
Yes. I have given the legible copy. Is the copy legible? The one? Yeah. Yes. This here it is written 5-year integrated BLLB honors 10th semester examination 2020. This is by Nilima Murmu. Nilima Murmu mark sheet. Nilima Murmu.
You are saying
Yes.
to others they have given. To me they are not giving. I have also answered that.
Lordship.
You should show
Lordship.
to claim equality. What you have to say is
Lordship.
not only that you should be treated, others have been given particular benefit. So what has been given to others is absolutely according to law. If what is given to others is wrong, a wrong does not give rise to a right in your favor.
Lordship, but the other
Maybe take this matter of vacation so that this may come before some other judgment.
Yes, Lordship.
First of vacation. At the request of counsel for the petitioner. Why you are discriminating? All these problems arise because of your university acts. For one set of students, you are saying like this. To other students, you will say 7 years. For others, 5 years.
In fact, that is the thing which pinches the shoe, and I have called for clarification because I was not sure of those what was the issue. So, if your Lordship is calling it after vacation, I'll clarify. No.
Lordship, may kindly give a short date kindly because the petitioner has APP exam expected
When
to
it
be
is examination.
The notification is expected to be out next month.
Expected to be out.
Yes,
Post
next
this
month.
matter in the second week of September, October. Yes. Fast.
Fast.
Minutes, item 40 permitted for time for file regenter.
Sir, can you give time? After 4 weeks, at the request.
Item 41, my lord. Covered by the Ananta Kumar Naik judgment.
51 is covered.
My lord.
I'm for the university.
Covered by judgment. I will change the dates and other things.
Yes, my lord.
41 and 43.
44 also same. I have corrected.
You corrected.
My lord.
I'm 42.
Let us go one after another.
One after another. Correct. This is serial number
41.
41. Correct. Tell now a WP number. WP number 3140 of 20. 2041 is over.
In 2 minutes, I will take time, please.
42
also covered by the Ananta.
He wants time to answer. After vacation.
44 minutes covers.
43 is covered. 43?
43 also.
43 also covered by the
43 is give that.
44 is covered by also Ananta case.
My lord. I have corrected all these dates and
all these judgments you have.
Oh my lord.
I checked all minutes that is covered by Ananta.
44 covered.
44. That's I checked each items.
All items.
By Ananta men.
My lord. All these judgments I have corrected.
45.
Sir, 45 has been answered. Item 46.
46 your lordship order.
Check that. Just show that 46 is covered. Your dates and other things you have changed. No dates, only reporting.
Oh, yes, ma'am. Press definition.
Same prayer.
Ma'am, same prayer.
Identical prayer.
Total identical.
Item 49.
My lord, the lordship asked me that what is the injury. I have brought that injury which is now going. In a very critical condition, my lord, your lordship tried to should just out, my lord. To that implantation was made, my lord. On two end of implantation, my lord, this if it became septic, the black portion it is not marked in photograph, and the black some portions became black, my lord. Now. It is also last photograph, my lord. It is clear, my lord. That portion has last but one photograph. Became black one photograph. You are unable to walk.
You are not allowing me to go through also.
Pardon me.
Yes, see the order date is 25/9.
Yes, ma'am. I have sought for the information matters as directed yesterday, and I have.
What they have said?
Well, they have said 2 to 3 points, Milan. Number one was the Shiksha Sahayak appointed in the year 2015.
2015.
15/1/2015.
Yes.
And from 12/6/2015, he is continuing at Bhubaneswar Mala as of now.
Yes.
But so far the disability certificate is concerned, it is available at page 22 of Annexure 7 to the REIT application. For a moment, Miller.
Disability certificate.
At C, Miller.
See, here 60%.
60% in figure, 60% temporary in relation to the
of body.
As per the guidelines of the special, the certificate is recommended for 2 years, which is ended in 11/4/2021, Miller.
You subject him to
next page, my lord.
Yes, sir.
Kindly take the next page, my lord.
I'm coming.
23.
So the next page is at page 23.
Yes.
This is given by the CDMO PHO Cutter, wherein also they have recommended so far the standing and all other things are found, but no disability is concerned, man. Can have a glance to para 2, my lord. Very fairly they have submitted.
Yes.
So far the government is concerned. The standing medical board
examined him along with treatment records from so and so.
Yes.
Opined that it is a case of post-operative fracture, fracture shaft of femur with residual deformity,
and advised
to avoid strenuous physical activities like frequent stair climbing, prolonged walking and standing. I am enclosing here the copy of the proceedings first. Yes, brother.
Yes.
That, my lord, thereafter now the president
they have come with a disability certificate. No, apart from that, the online process is on, Miller, as of now. They may apply for the same.
I have already.
This will be considered, Miller, and this is under consideration because it is on, Miller.
I have already applied.
And so far the disabilities,
sir. You are disturbing too much. You are not permitting him. You are not permitting him.
Sorry, man. Sorry.
What kind of notice is this? Yes. What is that you said? Online?
Online application by virtue of the government in portal also. They will apply by not physical. They can apply for the transfer in online, Miller. That process is on.
For transfer.
Yes. So they need their prairies. So in between the Bhubaneswar vicinity, they can be accommodated as your lordship has directed me to do. So to that effect, I have immediately received that information. So for the
factual to apply.
Exactly.
Where are the vacancy?
Nearby, I have also approached by what fell from my Lord's mouth, my lord, to please consider keeping in view. But so far the disability is concerned, so far the record is concerned, it is not at all available.
It is
apart from that humanitarian point of view. Exactly. They can consider, I have also instructed them to consider the nearby, by that he can get the medical treatment at the earliest because of this illness. So for the amputation, all other things, there is no document nor
no amputation.
Exactly. Nor in Annexer 8, nowhere it is suggested that is it a disability certificate is there, percentage, because it ends in 2021.
Even according to second this one.
Exactly. That is my humble contribution.
You apply for...
I applied Annexer 14, my lord. I have online, I have made an application, my lord.
Annexer 14?
Yes, my lord. Application has been accepted, my lord. Lordship, I will pay 60.
No decision is taken on that?
None that, my lord.
The short grievance of the petitioner is as to non-consideration of his representation dated
the application, that the application number is 211703 of oblique 2025 oblique RM 0.
Date is not there.
Date is not there, my lord.
29/7/2024. Correct. 29/7/24, correct date?
29/7/2024, my lord.
24. At Annexer 10, wherein he has sought for his transfer from X place to any nearby school in or around the vicinity, in the vicinity of Bhubaneswar on medical grounds. First, counsel for the petitioner vehemently argues that can kindly be seated. Sit down, person argues that Mr. Mohanty, please be seated. His client, having met a severe vehicular accident, underwent medical intervention, surgical intervention, and he has to undergo periodic treatment, post-operative treatment and care, which are not available at the present place. First up, he draws attention of the court to certain medical records in that connection. First up, he submits that if the subject representation is considered keeping in view the medical and health condition of his client, that would serve the cause of justice. First, next paragraph.
May I pardon, my lord, to interrupt, my lord. That representation which I made, my lord, that was rejected, my lord. As per the present transfer policy, my lord, I made the application under Annexer 14 again for transfer, my lord.
Annexer 14?
14.
Then you make
at page 60. Online application, only online application.
Date will be different now.
Date will be different, only your lordship mentioned application number, my lord.
Made online application.
The number is there.
Wide number 211703 for 2025 RM. So you are finding it at Annexer 14. Okay, that number. Rest of the things finds. Next paragraph. On the basis of pleaded urgency in the matter, this court, wide order dated so and so, go to the order, interim order, dated 25/9/2025, had said as at. Next. In terms of that, learned AGA Mr. Mohanty appreciably got the required information and submits that. He would instruct OP number. Two. This Director Elementary Education.
3 by
3. District collector.
District education.
No. Collector the chairman of the collector district level.
District level committee, my lord. It is a 3.
3.
OP number 3.
Yes.
To consider the subject representation, keeping in view the vouching material produced by the petitioner in accordance with law, if a reasonable period is prescribed. First off, he also tells the court that all contentions of the party should be kept open. Since the matter lies in the domain of OP number 3, who has to take a meritorious decision, keeping in view a host of factors. First off, with this proposal, counsel for the petitioner is also agreeable. You are agreeable?
My lord.
Not agreeable?
No, my lord. I pray one thing, my lord. Let your lordship that I will submit all my medical papers before the collector for.
That's what. The same thing I said.
Yes,
next one. In the above circumstances, this petition is disposed of. The subject application to be decided and the result thereof should be communicated to the petitioner within 3 weeks. First off, it is open to the petitioner to produce all and whatever evidentiary material to vouch the pleaded medical disability first. All contentions are kept. Within 3 weeks, you have to take the decision. Yeah.
Will produce within 1 week.
So, my lord, so for the
will produce all the documents for the collector
within
1 week.
Within 10 days.
Within 10
days. 3 weeks after thereafter. Within 3 weeks. That's permitted to do so. Well, the period of 3 weeks would commence
after the submission of the document.
Submission of evidentiary material by the petitioner. You do it tomorrow? Only tomorrow it will be.
Only offline, my lord.
No.
Well, that we have already mentioned. We are on the process, my lord.
Item 50.
50.
That
is yesterday your lordship directed
registration.
Yes. They have received the instruction that only the deed has been entered in the computer, but not yet registered. System, it has been entered in the system, but not registered. Your last line. And the reason that has been highlighted by the
reason is what? Vendor did not come.
No. The land, he telephoned me, but I think it is incomplete
information.
He telephoned me that out of the total land is available 561 decibel. Out of which already 507
is
sold. So what I pray, my lord, if your lordship call this matter after vacation, so I will be able to give
put everything.
Yes.
Okay?
Yes.
My lords, can I permit? Lords, may kindly see, admittedly, they have entered the document for registration.
Correct.
In the computer. And everything I have given my LTI, my face mark, everything.
Apex court say what is meant by registration. But there are two decisions. With this, it will not be. There are two decisions. Anyway, I will not so easily leave them. I will call this matter on the 23rd. No, not 23rd. On 17th. 17th. All right. Yeah. One password matter. Which is that? Call
one Passover matter was there, that amendment. I had received copy, but my senior is not there.
Just one thing, you open the jail also. In the item number 24, your lordship, the lordship has directed the petitioner to take admission in the caste certificate of the father. Lordship school had been earlier, lordship state the one of the seat reserved for the petitioner. Name of the school maintenance.
No, I will not mention that. Which school we don't know. Wherever you produce it, according to that it will happen.
And sir, 6 your lordship has state one of the
That's all.
one of the seat your lordship.
Yes.
Lordship, I have served a copy.
You have served the copy. You call it after vacation. We should call this matter soon after vacation.
Date may be fixed.
New copy.
I've given the copy.
You have given the copy?
Yes, I have received.
Yes. You file the objection.
Yes,
Biscuits, I have mentioned the name of the school.
You have mentioned, but I will not give because I do not know.
Your NSR 6 your lordship order is there.
Correct.
Earlier order is there.
That's all.
Your lordship reserved the seat to one of the seat.
Reserving the seat?
Yes, ma'am. Your lordship, NSR 6 your lordship.
I have told the authority, school should act upon your father's certificate.
No, that your lordship said that one seat is reserved till the disposal of the appeal, your lordship. The principal of the institution is requested to keep one seat till the disposal.
Millard has directed to act upon as per the earlier issue, and the appeal order has been stayed. So if it is stayed, then it will remain as it is. So that can be very well utilized in the school.
That is what I have said, but
Millard
he wants
has
that it should be
directed that.
school specific.
Yes, ma'am. Your lordship has given the direction. NSR 6 your lordship has given the direction.
What is the meaning of keeping one seat?
If at all it will be considered.
Admission will help you.
Yes.
It in admission and
I am telling you to admission, for admission only.
Admission, your lordship has given the direction.
In the earlier
NSR 6.
school, which is the serial number?
Serial number, my lord.
Which is WP number? Your serial number in the list. You should know, na?
24.
Just show that order to me.
Your Lordship, item 36.
Okay.
Interim order to continue, Your Lordship.
Interim order to.
Your Lordship, may I make a small prayer, Your Lordship? I have filed an IA application for stay, Your Lordship. In that IA application, I have mentioned that instead of BSKY, it should be AB, PMJY, JJI portal should be accessed, Your Lordship. That may be allowed at least, Your Lordship.
That rectification will allow that. There is interim order.
Yes.
Application in
Like C, Your Lordship.
IA number
15963.
15963 of 2025, supported by an affidavit, seeks a small clerical correction in mentioning the what is that?
AB, PMJY.
Mentioning name of the hospital.
No, Your Lordship, it's the scheme, Your Lordship.
Mentioning the name of the scheme. So that the interim order granted by this court becomes meaningful.
Your Lordship.
First off. No prejudice will be caused to the other side if such a rectification is allowed. First off. Next, in the above circumstances, application is allowed, and where it should be mentioned?
Your Lordship.
The interim order shall be read.
Let the E put
as relating to AB PMJAY
Your Lordship.
dash CJAY GJAY portal.
Your Lordship.
Portal. And to extend all the benefit, that's all. GJAY portal. That's the point. That application, just to see how they are rectified. Wish you all the best.
Happy Puja from the bar.
Enjoy festival. Spend time with
family,
spouses, children, relatives, friends, and come back afresh after the reopening. That is all.